Thank you, Chairman Grassley. Thank you, Judge Kavanaugh, to you, to Ashley, to your family and friends. Thank you for being here and for the opportunity to engage with you again. You've certainly shown great persistence and engagement. In the last round, we talked about the bedrock constitutional principle that no one should be above the law, including the president, which is a principle foundational to our democracy. It's about more than any one person, any one president. And I just want to continue asking you about the president's obligation to cooperate with a federal investigation and how your view of the president's power might implicate an investigation. As we all know, in 1974, senior officials in the Nixon administration and the campaign were on trial for crimes related to Watergate. And with so many former White House and Justice Department officials implicated in crimes, then President Nixon felt threatened by the investigation. So Special Prosecutor Archibald Cox, when he issued a grand jury subpoena for the Watergate tapes, audio recordings of White House conversations, reasonably believing they contained evidence of criminal activity, the president acted. Instead of complying with the subpoena for tapes and providing the evidence, President Nixon had the special prosecutor fired, and he fought the subpoena for the tapes all the way to the Supreme Court. I want to focus on the question of the president's action in firing the special prosecutor, because that's what I think is a key issue here. Judge, when President Nixon fired Special Prosecutor Archibald Cox, did he violate the law or the Constitution?
Look
Why are you marginalized women and minorities? Why are you my lord? Why did you do it?
I know that the regulation in place for Leon Jaworski after the firing had special protection against firing, and I think that's become the model for the regulations. I'm not recalling the specifics of the Cox regulation in place at the time.
I'll tell you that there were for-cause restrictions in place in regulation at the time. Given that, do you think firing the special prosecutor violated the law or the Constitution?
Well, if it violated the regulation, it violated the regulation.
Would it have violated the Constitution? What I'm getting at, Judge, is your view of presidential power and whether or not it would be a violation of the Constitution for there to be these for-cause restrictions on the president's ability to fire the special prosecutor.
Well, I think the Supreme Court in United States versus Richard Nixon analyzed the specific regulation at issue in that case and actually relied on the specific regulation in finding that the case was justiciable under the precise terms of the regulation in place at the time. In fact, the court analyzed that in really specific detail, pointed out that so long as the
Let me be clear about the point I'm trying to get to.
Okay.
It's your views about whether or not, when President Nixon fired Archibald Cox, he obstructed justice in violation of the Constitution, or the firing itself violated the Constitution. It's important to know your views on U.S. v. Nixon as well, and we'll turn to that. But I'm interested in your understanding of the Constitution and whether or not it prohibits restrictions on the president's ability to fire a special prosecutor at will.
So the Supreme Court said, and so you're asking my views are what the precedent says. In other words, I follow the precedent. The precedent of the Supreme Court in the U.S. v. Nixon case did apply that regulation, analyze this.
And Judge, U.S. v. Nixon was unanimous, correct?
It was unanimous, 8-0.
Are you aware of any justice having questioned the decision in U.S. v. Nixon since then?
No, I've called it one of the 4 greatest moments in Supreme Court history, U.S. v. Richard Nixon.
You have, and that's exactly what I want to get to, because you've also, in another context, as we talked about yesterday, in a roundtable in 1999, volunteered unprompted that maybe Nixon was wrongly decided. Do you think U.S. v. Nixon was wrongly decided?
I've said it was one of the 4 greatest decisions and correct decisions in terms of the specific regulation at issue in the case, and the court's holding in the context of a criminal trial subpoena, that the subpoena for the information, the tapes, was enforceable in that context. And that's what I've said before publicly about the Nixon case. And
so,
that
Judge,
1999...
you would agree that it was correctly decided? Did I just hear you right?
Yeah, of course. When I say it's one of the great... I mean, when I say something's the greatest, that means I agree with it. And the point was, under the specific regulation at issue in that case, a criminal trial subpoena for the information. And it was a moment of judicial independence, a moment where the court, I think, came together as a unanimous opinion written by Chief Justice Berger. So that's an important moment in the court's history.
So you'd agree then, just following the U.S. v. Nixon precedent, that a court can order a president to produce records in response to a grand jury subpoena, or can be compelled to testify in front of a grand jury?
I'm not going to answer hypotheticals about how to apply U.S. v. Nixon.
But that is the holding.
The holding of U.S. v. Nixon was that the subpoena for the information in the context of the criminal trial could be enforced, and that therefore, given the regulation at issue in the case was justiciable, and the subpoena could be enforced. I'm not going to answer hypotheticals about how it applies in other contexts. By the way, I should add that the context of what you have up there is incorrect. But I've said Nixon was one of the four greatest moments in Supreme Court history. I've written that several times before, including
You have.
1999. The context of that, if you want to know, was a roundtable
Yes.
with me and some lawyers who had represented the Clinton administration. We were just talking, reflecting on the
Yes.
independent counsel investigation. And my point to them, they were concerned that the subpoenas that were enforced by the courts during the Starr independent counsel investigation had weakened the presidency. That was the position of the Clinton lawyers. And I said, well, we were just following U.S. v. Nixon. That was my position. So my position was either you're wrong or Nixon's wrong to the Clinton lawyers. And that's the context of
Right.
that comment. The tone of voice there makes the printed words look much different from how they were intended, and I think that's been seriously mischaracterized, frankly.
And the striking thing about the context, which we've discussed before, and I made clear in a letter I was going to question you about, is that Phil Kavanaugh, who was facilitating this roundtable, who was a Watergate prosecutor, who argued U.S. v. Nixon, in a later interview said he didn't think you were just being provocative. This was just some academic give and take with some Clinton lawyers. Kavanaugh has been quoted saying that statement, that perhaps Nixon was wrongly decided, was Brett staking out his jurisprudential approach since law school. It seems Kavanaugh thought you were serious about raising a question about whether U.S. v. Nixon was wrongly decided because, and this is what you said at the roundtable, Nixon took away the power of the president to control information in the executive branch.
Right, and that's why the Clinton lawyers, I thought, were wrong.
So
That was my point.
why should the person being investigated?
The point I was making was that the Clinton lawyers who were saying that the independent counsel office had weakened the presidency, I was saying to the Clinton lawyers, it wasn't the Starr office who had done that. It was United States versus Nixon that had done that. And then I pointed out to the Clinton lawyers, I think we've discussed this in the office, had a good discussion in your office about this, I said, but you were unwilling, I said this to the Clinton lawyers, you were unwilling to challenge United States versus Nixon. Well, that was the governing precedent, and that's the precedent we were litigating, and that's where your concern should be, and that's the context in which that line was said. With all respect to Mr. Lacavera, I think he's misunderstanding what I was saying there, and here's how I know he was misunderstanding, because in a contemporaneous law review article at that same time, I specifically talked about U.S. v. Nixon and the importance of that precedent, so that's how I know he was misunderstanding the point of what I respectfully think he was misunderstanding the point of what I was saying there.
So if U.S. v. Nixon was rightly decided, was Morrison v. Olson rightly decided?
Well, I've talked about Morrison v. Olson.
Yeah.
That was
the whole point of our exchange yesterday, and that's
Yes.
the root of my core concern. And what I'm getting at
I've
in this whole
associated
line,
myself with Justice Kagan's position on Morrison v. Olson.
and given our exchange yesterday, I went back and looked at presidential administration, her article where she expressly rejects Unitarianism, as she calls it, the unitary executive theory, the theory that you don't just mention in passing but expound in your PHH dissent.
I don't.
And it's exactly this reason that I have concerns, Judge.
But I specifically recognize, Senator, and I understand the point, but I specifically call Humphrey's executor the precedent that we must follow in the independent agency context. Humphrey's executor, of course, accepts independent agencies, as did I in that case, as precedent of the Supreme Court that I've referred to as entrenched. The only question in PHH was, can we go further than that kind of independent agency consistent with Article 2, or does Humphrey's executor draw the line that sets forth the permissible boundaries under which Congress can establish independent agencies?
And in an exchange you had with Senator Feinstein earlier today, this was exactly the question where I don't think you ever really answered it. As I understand your dissent in the CFPB case, PHH versus CFPB, your exact problem with the structure Congress created for this independent agency was that the director was not removable at will by the president. The director is removable, but only for cause. That's the line that I'm drawing here between your concerns or criticisms in one context a long time ago about U.S. v. Nixon, your comments about being able to fire the prosecutor at will in a number of law review articles, your comments in some roundtables and discussions in 2016, and the dissent in PHH, and the structure of the CFPB. What offended your constitutional sensibilities, as I understand your dissent, Judge, this year in PHH, was that the president couldn't fire at will the director. And that's the whole reason of my asking you about, did the president violate the Constitution in your understanding in firing the special prosecutor in Watergate? It is a coherent theory. You can have a coherent theory that the Congress can't restrain the president's ability to fire at will lesser executive branch officials. I just want to have a clear understanding of it.
I want to understand the question. So the first part of the question was part of your premise.
So earlier today, let's return to an earlier exchange you had with Senator Feinstein. She's asking you about your dissent in PHH. What was it that caused you to write an opinion? What was the constitutional view, the underpinnings of your decision that having a single director removable for cause by the president was constitutionally unsound?
Okay, I can explain. Can I get a minute?
Yes.
Okay. So I was following a precedent of the Supreme Court from about 10 years ago, Free Enterprise Fund case. I'd written a dissent at the D.C. Circuit in that case, a novel independent agency structure for the PCAOB, the Accounting Oversight Board.
I'm familiar.
I wrote a dissent saying that that structure departed from the traditional independent agency structure. I dissented. The Supreme Court took the case, agreed with my dissent, in a majority opinion by Chief Justice Roberts, saying that the outer lines, at least as I interpret what Chief Justice Roberts said for the court, the outer lines of independent agencies are the traditional independent agency structures set forth in Humphrey's executor. At least that's how I interpreted the opinion.
But wasn't Humphrey's executor also, Judge, critically about removable at will versus for cause?
Yes, and that's that. So long as it's set.
And isn't this exactly why the majority in your circuit said that your dissent flew in the face of Morrison?
They thought Humphrey's executor allowed structures beyond the multi-member agency that was upheld in Humphrey's executor. I disagreed based on the free enterprise. The same thing had been said about my dissent in Free Enterprise Fund. The Supreme Court took it and agreed with my dissent in Free Enterprise Fund. I thought this case is very similar to what I had written in Free Enterprise Fund. In fact, I block quote my old dissent.
But what you didn't say in response to Senator Feinstein's question that I'm still trying to get an answer to, wasn't your core concern in your PHH dissent that the president could not fire at will the director of the CFPB?
That was the concern because that departed from history to have a single director independent agency structure, not the multi-member independent agency structure that had existed in Humphrey's executor. And
you can see how that then raises questions and concerns about your distinction between fireable at will or fireable for cause. And as this body has taken up and debated whether or not it is permissible for us to legislate a protection for special prosecutors that they can only be fired for cause, not at will, your repeated citation of the Scalia dissent in Morrison v. Olson rises again to the fore. Thus, my question to you, will you also agree that Morrison was correctly decided? It is good law. It's a settled case. You may have, in a response to a previous question, said, oh, it's a one-off case about a now extinguished statute. Right. But as I said yesterday, why then pick it out of the whole constellation of constitutional opinions as the one you most want to put a nail in its coffin? Why the animus against this if you don't think it was wrongly decided?
I've said what I've said about Morrison, but Justice Kagan said that it's one of the greatest dissents ever written by Justice Scalia, which,
Yes.
unless I'm misreading something.
You are misreading something, Judge, with all due respect. I went back to look at presidential administration by Justice Kagan after you cited it to me yesterday. That is clearly not what she's saying.
She
She's
doesn't
not
say-
endorsing
Yeah.
the unitary executive.
You're conflating.
She's saying Scalia wrote a beautiful dissent, in my view.
You don't think she agrees with it?
I don't think she agrees with it at all.
I think when she calls something the greatest, she probably agrees with it.
But let's get to what you believe. What I'm encouraged by is that you've said when you call U.S. v. Nixon the greatest, you think it's rightly decided. What I'm not getting an answer from you on is whether you think Morrison v. Olson was rightly decided. But I'd be interested in hearing whether you think Griswold versus Connecticut or Eisenstadt versus Bard were correctly decided. An opinion that Justices Kennedy, Ginsburg, Roberts, and Alito proffered when they were before this committee in their confirmation hearing. Were those correctly decided?
I think I said last night in response to Senator Harris, who asked me about whether I agreed with Justice Alito and Chief Justice Roberts on that. I said yes.
That they were correctly decided?
I answered that I agreed with Justice Alito and Chief Justice Roberts.
Can I just take a minute and explore your view of the independent counsel, the idea that the independent counsel statute is unconstitutional? Because you've written and spoken about that repeatedly in 1998, 1999, in law journal articles and public speeches. As I perhaps pointedly raised yesterday in 2016, you called the independent counsel statute a constitutional travesty.
That's what Senator Durbin had also, in essence, called it.
Well, what I'm concerned about is what you
And
said about it, because you're the nominee for the Supreme
entire
Court,
Congress,
not Senator Durbin.
the entire Congress had basically taken that view in 1999 that it was unrestrained, unaccountable, a disaster.
Let's say it was widely panned.
But it's very
But
different.
you chose to call it out as a constitutional travesty, and you're the nominee for the Supreme Court in front of me. So just give me a moment. While you worked for Ken Starr as independent counsel under the independent counsel statute, you took an oath of office to defend the Constitution, correct?
But as interpreted by you follow precedent of the Supreme Court. If the Supreme Court's upheld something, you still work in your public service.
You took an oath, you were engaged in public service, you believed then, as we all do, that it was your job to act in compliance with the Constitution, but you also fully utilized the tools available to the independent counsel, right? You were part of a team that sought a subpoena against President Clinton for evidence, for DNA evidence. Yes?
Can I get 30 seconds?
I think this is a yes or no question. I'm down to 2 minutes.
Can I get 30 seconds?
If it's your last 30 seconds.
Okay. I want to emphasize that the special counsel system that's in place now is something that I've specifically, repeatedly, and expressly said is consistent with our traditions in my 1999 Georgetown Law Journal article and in the CFPB decision. The special counsel system, I've said, is part of our tradition. That is the system in place. You're talking about something that has not been in place for 20 years.
That's right. The independent counsel statute, that structure, hasn't been in place for 20 years. My core concern, first, was that you were perfectly happy to use all the tools available to the independent counsel when you worked there. After working there, discovered an enthusiasm for its invalidation as a constitutional matter. In trying to understand that, I've dug into your writings, your opinions, your speeches, and concluded that you hold a view of the executive branch, which I believe you made clear this year in your PHH dissent, which I believe is in line with Justice Scalia's view as expounded in his dissent in Morrison v. Olson, which is that there has to be in the president, as the chief law enforcement officer of the United States, this is the unitary executive theory, not mine, the ability to fire at will any special prosecutor, and the ability, and I've got quotes from you in different contexts saying that what's appropriate in this traditional special counsel setting, like the Watergate period, is if the president disagrees with the conduct of the prosecutor, he should simply fire him and bear the consequences. My point essentially is this. I'm convinced that you've said repeatedly you support the traditional practice of appointing special counsels, but you haven't acknowledged you've supported this practice because the president has retained the power to fire the special counsel at will. And those of us who have tried to enact statutes that might restrain the president in some way by putting in place for-cause removal restrictions have had thrown back at us the dissent from Morrison v. Olson, a dissent which you embrace and cite, and a dissent which I think reveals a deep commitment to a view of the president that in our current context is profoundly dangerous. And I simply wish, Judge, and we'll have a third round to explore this, I simply wish you would be clear with us and the American people about your view of the scope of presidential power and what its consequences might be. I don't think you're being direct with me about that, because I think to be direct with me about that in this context would put your nomination at risk.
I respectfully disagree, Senator. You're talking about a statute that has been not existed for 20 years.
That's no longer what I'm talking about, Your Honor. As you know, what I'm talking about is your view of presidential power as made clear in speeches and in writings and in a decision this year. We're not talking about the independent counsel statute now. We're talking about the scope of presidential authority, and I think it has consequences for our nation.
You can answer.
You are clearly a capable and good man,
You can
and a good
answer.
neighbor and a good coach, and we've heard a lot about that. What I want to hear more about is an honest answer about your view of presidential power.
You can answer.
You're talking, if I can answer uninterrupted for
You can
45
answer.
seconds.
You can answer on the 10 minutes I didn't use.
Yes. Respectfully, Senator, first of all, I appreciate your care, and we've known each other since law school, been friendly with each other since law school, and your devotion to this. Respectfully, I believe you're talking about a statute that has not been in place since 1999. Secondly, the special counsel system I've specifically written about multiple times and approved. Thirdly, if there were some kind of protection, for cause protection or some other kind of protection that were different from the old independent counsel statute, I've said that I would keep an open mind about that. So I have not said anything to rule that out. And finally, I've reaffirmed repeatedly, or I've applied repeatedly, the precedent of Humphrey's executor for traditional independent agencies and have never suggested otherwise. I've referred to that as an entrenched precedent. So those are, and I've referred to U.S. v. Nixon as one of the greatest decisions in Supreme Court history.
Great. Thank you, Mr. Chairman. I ask unanimous consent that letters from 8 different groups, organizations, individuals be entered into the record.
Without objection, so ordered.
Thank you. Judge Kavanaugh, we're at the end of a long day. And I'd like to take a few minutes and just explore with you a speech you gave last year, a speech at the American Enterprise Institute entitled The Constitutional Statesmanship of Chief Justice Rehnquist. There you called Rehnquist your first judicial hero, and you went on to discuss at length the 97 case Washington v. Glucksberg, in which the Supreme Court rejected a fundamental right to physician-assisted suicide. In Glucksberg, as you know, Rehnquist explained his belief that the only liberties protected by the Due Process Clause are those that are, quote, deeply rooted in the nation's history, legal tradition, and practices. You praised Rehnquist's opinion. You said, and I'm quoting your speech here now, the Glucksberg case stands to this day as an important precedent limiting the court's role in the realm of social policy and helping ensure the court operates more as a court of law and less as an institution of social policy, end quote. You further praised Rehnquist as a justice who, I think I'm quoting here, was successful in stemming the general tide of freewheeling judicial creation of unenumerated rights that were not rooted in the nation's history and tradition. The only conclusion I can draw from your praise in this speech last year of Rehnquist's substantive due process jurisprudence and his Glucksberg opinion is that you endorse this so-called Glucksberg test, which asserts the only substantive due process rights protected by the Due Process Clause, are those objectively rooted in American legal history and tradition. You even said yesterday, in a similar exchange here, that all roads lead to the Glucksberg test. So let me, in the few minutes I have left, ask a few quick questions about the implications of applying the Glucksberg test in a principled fashion.
Can I say one thing first?
I want to get a couple questions quick, and then, depending on the grace of the chairman, we may have an exchange.
Said the same thing Justice Kagan said when she was in this chair about Glucksberg.
And here's the most important thing about Justice Kagan's jurisprudence. She did not apply the Glucksberg test in U.S. v. Windsor, in Obergefell, or Whole Woman's Health. So the question I want to get to is, what would it mean to go and apply this test in a range of settings? So first, is judicial protection of the fundamental right to access and use contraception consistent with the Glucksberg test? Just, it's a simple yes or no question, Judge.
I disagree that it's a simple yes or no question. What I've said here is that the precedent of the Supreme Court on that question, what Justice Alito and Chief Justice Roberts said about those
Yes.
precedents, Justice White's concurrence in Griswold is
Yes.
persuasive application of precedent. What's important to know about Glucksberg is it cited Planned Parenthood versus Casey as authority.
Yes.
As authority.
But on the specific issue of contraception, and I appreciate your having said those were correctly decided, I'm just trying to get clarity about if it were the Glucksberg test, well rooted in our history, legal tradition, and practices, would the court have ever reached those results on a fundamental right to access and use contraception, given the long history of states having statutes that prohibited access to contraception?
Well,
think
as
it's a simple
Justice
yes
White
or no.
explained in his concurrence in Griswold, actually, those laws had not been enforced for decades. But put that aside, the test in Glucksberg, as Justice Kagan explained when she was sitting in this chair, is a test that is guiding the Supreme Court going forward and has been cited in the precedent. It did not disturb any pre-existing precedent, indeed cited Casey as authority.
It did. So let's move on then to abortion, which was really centrally at issue in Casey. Is judicial protection of abortion rights consistent with the Glucksberg test, something deeply rooted in our history, legal tradition, and practices?
Again, I think it's important to underscore that the Glucksberg decision written by Chief Justice Rehnquist cited Planned Parenthood versus Casey as authority, which in turn Casey reaffirmed Roe v. Wade.
But had it been the test at the time, the court would not have reached that result. In fact, you said at the AEI lecture, even a first-year law student could tell you the Glucksberg court's approach to unenumerated rights was not consistent with the approach of the cases Roe v. Wade, Planned Parenthood versus Casey. So we know the Glucksberg test, had it been applied, wouldn't have reached that same result. Let's move, if we could, from contraception, abortion, to intimacy. Is the Glucksberg test consistent with the court's historic decision, Justice Kennedy's decision in 2003, Lawrence v. Texas, which the court held the Constitution protects intimacy, including same-sex intimacy between consenting adults?
Well, as the Supreme Court said last year in a broad majority, under the precedents that now exist, the days of treating gay and lesbian Americans as second-class citizens, gay and lesbian couples, or inferior in dignity and worth are over. That was Justice Kennedy, joined by Chief Justice Roberts, Justice Alito, Justice Gorsuch, Justice Breyer, and Justice Kagan. A statement for the Supreme Court summarizing, in essence, Romer, Lawrence, Windsor, and Obergefell.
But had the Glucksberg test been the sole test being applied during Lawrence, Justice Kennedy would not have reached the result he did.
Well,
Let's move to the right to marry, if we could, for a moment, because this is the last case we're going to get through.
Windsor,
the right to marry is clearly rooted in our history, legal tradition, and practices. Yes, Judge? And we both know the landmark case, Loving versus Virginia, distinguishes marriage is clearly deeply rooted in our history, legal tradition, and practices.
Right.
But interracial marriage was not. In fact, it was barred in many states, probably longest in Virginia. And the Supreme Court struck an important blow in 1967 in striking down anti-miscegenation statutes. Last, what about same-sex marriage? If the Glucksberg test were the test applied, is a right to marriage, regardless of gender, deeply rooted in our history, legal tradition, and practices?
A couple things, Senator. I think Windsor and Obergefell talk about equality as well. So there's an equality principle, and as the court said in Masterpiece Cake Shop, summarizing all those decisions, a line of 5 decisions, all written by Justice Kennedy, Romer, Lawrence, Windsor, Obergefell, and Masterpiece Cake Shop.
Were they all correctly decided?
They're all, none of the 8 currently sitting justices have answered questions about any of those cases. As Justice Kagan said, no thumbs up or thumbs down on those recent cases. But what the court said in Masterpiece Cake Shop is the most recent statement of the Supreme Court for a broad cross-section, a large number of justices on the Supreme Court. And I think I'll leave it by referring you to that statement from the Supreme Court.
Here's my core concern. This quote, what you chose to do in a speech last year in front of AEI was to lift up this Glucksberg test. What you chose to say yesterday, all roads lead to the Glucksberg test, gives me pause and concern. If you feel I've somehow misquoted you in the American Spectator article, if you feel I've somehow misquoted you here, I expect we'll have a chance through some written exchanges to give you an opportunity to further clarify that, given the limitation on my time now. But in what I've read about how the Glucksberg test has or hasn't been applied, the ways most critically in which Justice Kennedy himself rejected the Glucksberg test in his opinions in Casey, in Lawrence, in Obergefell, I think the Glucksberg test is better at rejecting claims of constitutional rights than it is at accepting them, and I think it's a blunt instrument, and I'm concerned that it may reveal an enthusiasm for a test that would permit the continued exercise of government power in ways that frankly would blow up all modern substantive due process. If applied rigidly, it would blow up precedent in contraception, abortion, protection from sterilization, marriage, a whole range of areas. These are settled precedent. But those of us who sit trying to decide whether you should be the next justice and take Justice Kennedy's seat have to ask ourselves what your views would be. And in this recent speech where you cite your first judicial hero, Rehnquist, in articulating the Glucksberg test, I worry that you reveal you don't share the view of our framers, in particular the 14th Amendment framers, who understood constitutional rights to exist in significant part to right historical wrongs, not to ignore them or entrench them. Our Constitution's protection for people who are vulnerable or marginalized or just different from the majority is what makes us a beacon to the rest of the world where there are so many countries where minorities or those who dare to live their lives differently are marginalized or oppressed. And it is exactly this Glucksberg test that worries me most because it excludes all such people from the circle of constitutional concern and protection. I'm troubled, Judge Kavanaugh, if you don't understand that as the driving, animating force of our constitutional culture. And this is a test that, in my view, is just not up to the task of vindicating our country's greatest ideals. Thank you.
If you feel you want to comment, go ahead, and then I'll call on Senator Lee.
2 points. Justice Kennedy joined Glucksberg. Justice Kagan cited Glucksberg repeatedly when she was in this chair.